election and is looking for advancement. I don't mean by this to condemn all judges, and I certainly hope you won't condemn all lawyers. There's a lot of struggling lawyers actually out there. They're not likely to have much money, but we have to unite about these rules and about the appointment of judges, and we are at a really critical time. With the current Congress is about to appoint all kinds of judges. There's been a lot of federal judgeships that were not filled. I don't really frankly care what their political parties are. I don't think judges are supposed to be politicians. I think that their political affiliation should be irrelevant. The key is, will they apply the law the same for you as they will for a prosecutor? Will they apply the law the same for you as they will for corporations, corporate defense attorneys, insurance companies who want the law applied equally? And if they cannot do it, they are not fit to be in those positions. We just heard George, and obviously he had a moving experience with the court. I can just imagine having a jury verdict 3 times taken away from me. These things affect us all very personally. My entire life and my family life has been completely transformed since I attempted to litigate corruption claims in Norfolk. These things affect us all in a very, very deep and personal way. The courts are critical to our lives. They make decisions about the custody of our children, about our property, about our employment rights, and critically, our constitutional rights. So, I guess I just hope that I'll hear from you in the future. I am circulating some petitions that are addressed to United States Congressman Sensenbrenner. He is the chairman of the House Judiciary Committee. I don't take any great pride in authorship in these petitions. There's nothing fancy or sophisticated about them. But I am asking that they start independently investigating in Congress claims of obstructions of justice by judges. Because I don't believe the Judicial Council are going to do it. We know they aren't going to do it. You look at the statistics, they have almost never disciplined in the federal court system. Almost never. You look at the state system, they don't even record them as official complaints. In 99, with some 500 complaints, they only opened inquiries into 27, and of those, I don't believe anyone was disciplined. And the congressmen who are voting on those Virginia judges' reappointments every 6 or 7 years don't even have the information that the Judicial Inquiry and Review Commission has available to it. It's a cover-up, let's face it, and let's try to uncover it. Back to the jury. Give us back the jury.
My name is Wesley Ashton, and I'm a member of an organization called A Matter for Justice. I've been part of this organization for about 2 months now, but I joined them because I'm very excited about what they do. I'm not speaking on as a spokesman for the organization, but as an individual who came to a demonstration here today before the Supreme Court. I was a pro se litigant in a case that went before the Eastern District District Court, and you know, I was sort of excited to do that on behalf of a FOIA request.
hit with enough of these, and it's kind of funny. You know, people think Congress is not responsive. It's on the contrary. Congress is not responsive to one person at a time. If they get hit with 3 million of anything, the odds are they're going to enact it, because they understand that if they tick off 3 million people, somebody is going to have a problem. One of the things that we've got in mind, now you remember one of my favorite federal judges from yesterday, Rudy M. Brewster, can't tell the difference between witnesses and evidence, doesn't know when the Constitution was enacted, and thinks it's so vague he can't understand it. Well, what I'm going to show you here next, it's called Crossing the T, and I'm going to cover it very briefly except for this one particular situation. How many people here have read Erwin Rommel? See a show of hands. Okay, we got about a dozen. All right, excellent. Chapter 20, Crossing the T, simply tells you that what you want to do is you want to pick out one federal judge or who you want to get after, and you want to pour all your strength on him. Now, what we have in Rudy Brewster is we have a federal judge, and I see the transcript is still here, who has absolutely no business on the bench. Now, the odds are, if you file what is called a complaint for judicial misconduct. Now, I want everybody to pay real close attention here, because the rules of the game may change this year. It's Title 28, United States Code, Section 372, Paragraph C1. Now, what this is, what this does, this isn't a way for you to complain about a crooked ruling, because if you could, the entire court system would be bogged down with this particular statute. What this statute does, it allows you to file a complaint against a judge for conduct which interferes with the orderly administration of the courts. And what it addresses is mental or physical disability. Now, obviously this judge has demonstrated a mental disability. He can't understand the very document he's sworn to uphold. Every year, there are approximately 2,500 of these filed. 2,498 of them are filed by pro se litigants. 2 are filed by attorneys. Fact is, if you happen to be a licensed land shark and you're in there at the trough, you do not want to irritate the entire federal judiciary, because you attack one of them, you attack all of them. But what I'm asking for is I'm asking for volunteers for this mission, and this is the first time I've put this out, to call the Ninth Circuit Court of Appeals in San Francisco and ask them for the judicial misconduct complaint forms pursuant to this statute. They will not only send you the form, they'll send you a whole free booklet that shows you how you can do it in the other circuits too. And what I'm asking is everyone that's willing, wants to volunteer for this mission, to file a 372C1 complaint against this judge. Because here's what's going to happen. Let's say I've only got 20 or 30 of you here that file this. Or let's take a nice even number. Let's say, not even, a number we can work with. Let's say 25 of you here volunteer to go on this mission, okay? Now, what that does is that means that of the 2,500 judicial misconduct complaints filed this year, 1% of the total will be filed against one federal judge. But then what if you get your friends to do it, and the next seminar I give, I get another 25 people? The obvious goal here is to make sure this one federal judge gets hit with more judicial misconduct complaints than all the other federal judges put together. And what normally happens in a situation like this is that these type of complaints are kept track of statistically by the Administrative Office of the United States Courts. And the House Judiciary Committee reviews these statistics. Now, what do you think is going to happen if you've got Sonny Bono and his buddies all in the House Judiciary Committee, and they're all sitting there and saying, what the hell is going on here? We've got 5,000 judicial misconduct complaints, and 2,500 of them are against one judge. I'll guarantee you that judge is not long for the bench. Now, once you've taken him out, which we could probably do in a matter of months, then you go after the next one. And by the time you've taken the third one down, you've got every federal judge who sees the McGregor colors in his courtroom thinking, oh my God, I'm next. Okay, you know, I better treat this guy with kid gloves because he can hurt me worse than this land shark over here. Remember what I taught you yesterday? Path of least resistance. The But if, in fact, if you want, you're going to find that I will more than cooperate with you. If you don't even want to be bothered writing or calling the Ninth Circuit, there's our website. Just email us and we will send you the forms and instructions. We will even write it for you. Okay, it's http://home.earthlink.net/DLaw70/. And I'm hoping people will come up during the break and get our website. Now, the other website I have up here, this is Versus Law. And I think what's going to happen is the internet is going to create a problem that nobody has even suspected. Because this outfit, now we use it all the time, it's really a nifty operation.
What is that?
This is http://www.versuslaw.com, and Versus Law is spelled V-E-R-S-U-S-L-A-W. This operation here, for $75 a month, you can pull every Supreme Court decision from 1920 on up on your computer. If you're on the internet, you can pull every federal appellate decision back to 1950, and you can pull a lot of state appellate decisions back to 1950 up on this thing. I mean, if you don't ever want to leave your home and go to a better law library than they've got in a lot of universities, it's right there. It costs something like $75 a month. It's the biggest bargain in the legal field. Let's see here. I've got, I think I pretty well covered just about everything on that. Oh, yeah, one other thing here is that a federal judge, or rather a state court system, cannot hurt you if federal judges are doing their jobs, because state, or rather civil or criminal, there are statutes enacted by Congress to protect you. The problem is that you run into what are called judicial doctrines. You have Section 1983, which is anybody acting under color of state law. At one time it applied to everybody, but the Supreme Court decided to change that in 1967 and exempt judges. You have Section 2254, which is in Title 28, and that's federal habeas corpus for state prisoners. The problem that you're going to run into, and sometimes you can use this to your advantage, is that any time you see a judicial doctrine, the odds are it was promulgated with an eye towards making less work for the federal judiciary. We actually had a case out of Arizona in which we were squabbling about Title 28, Section 471. That's the Judicial Improvements Act of 1990. If you read the United States Code and Congressional, United States Congressional and Administrative News volume for that particular year, and you get to the Judicial Improvements Act, you're going to see that everything I'm telling you here, Congress is aware of. They know they're having a problem with these courts. The problem is they don't know how bad it is, and they think that they can fix it by enacting another statute for the very people who are causing the problem to enforce. And almost any human being will take the path of least resistance if you show a federal judge that if he goes with a doctrine this way, or if he goes with a statute law enacted by Congress that way, and this is this much work and this is that much work, guess which way he's going to go. And so what you've got is you've got to be very, very careful whenever you get into any type of litigation that you understand how many judicial doctrines you're going to run up against that were never enacted by Congress or by the people through the Constitution. I think this pretty well covers it for me right now. How many of you have got your case analysis? Okay, here's what I'd like you to do is I'd like you to come up. How much time have I got left on this segment, Peter? I've got 5 minutes. Okay, here's what we're going to do. I'm going to have Peggy come up and get started while I'm going to go back here, and so we don't interrupt anything. And I want all of you who have a case analysis, see what I'm going to do is I'm going to let my officers come up here and keep educating you while I have some time to go through your case analysis, because the worst thing you can do is look at something and make a snap decision in 90 seconds. Peggy, would you come up here on deck, please? And then what I'll do is I will come back. Also, if I have any volunteers, I'm not going to force anybody to do this, but I've had quite a number of people who bought my lawsuit cookbook years ago who've won some cases, and I'd like to have you come up after a while and give some testimonials. Peggy, on deck, you're on.
Good morning, everybody. My name is Peggy Daddick, and you've been hearing our names. My husband, Michael, is here with me this morning. Michael, if you'd stand up a minute. We fight together. I could certainly never do this by myself. Michael's my strength. I happen to be the one that does the talking because my husband was born in Croatia, and English is not his first language, so I'm the mouthpiece for the two of us, and that's why I'm up here and not him. And I'm really glad to have this opportunity to share our experiences with you, because I think what we've experienced, your knowing what we've experienced, can help you if you're going to be going into the court system. Michael's giving you some very important information. You've learned a lot here yesterday and this morning, and you're just being bombarded by a lot of details. But they'll all come back to you when you need them, when you go into court, if you go in well prepared. And being here is just a first step. You have to pay the price. If you're going to be out there fighting, you have to be better armed than the attorneys that are on the other side. And it's not hard, because most of them come in totally unprepared. I cannot tell you how many people have already been into court and are actively fighting a case. Okay, then quite a few. Then you've seen it. They come in, they expect, because you're a pro se litigant, that you don't have a clue about what you're doing. And when you go in there and you're ready, they're flabbergasted. The judge is flabbergasted. They don't know what to do. They don't know how to deal with you. When you come in and say, well, excuse me, Your Honor, but this is what the law says, and he comes back and says to you, well, no, you don't understand that, because you're not interpreting the law right, which is what your attorney will tell you. You can't be a pro se litigant because you don't know how to interpret. What he's telling you is you don't know how to read English. Well, I think most of us know how to read English, and most of us know how to make sense out of common words. And that's all that you really need to do. And what you have here, because I know we have a very strong Christian group here, is you have the very strong foundation that you need. All you need to fight in your court system is a very good understanding of what's right and what's wrong. And if you feel that something is really morally wrong that's happening to you, you're going to find a law that supports you. It's just, it comes from the Bible. It started back there. The history is there. We started out, we didn't have Michael Brown to help us out. And we were floundering, and we didn't have a clue of what to do. And we are certainly very thankful that we found Michael, because we would have lost our home 6 years ago to a crooked builder who put a completely fraudulent mechanics lien on our property. And we had Patriot mythology people saying, oh, go in and tell them they don't have jurisdiction, and because of the fringe on the flag. And but we sat back, and thank goodness we were smart enough to say, wait a minute, this doesn't really make sense. If people are telling you something that's true in the law, it's going to make logical sense. You're going to be able to find a law to support it. They're going to be able to show you case law that substantiates what they're saying. And basically, that's what you need to know to start out with. And as you're fighting in the court system, sometimes you get to the point where you say, I can't do this anymore. Are we ever really going to win? Does anybody ever really win? Well, a long time ago, probably about 4 years ago, I heard Peter Simpson on the radio in West Palm Beach. And I heard him say, a lawsuit is like a water carrying contest. And it's just a matter of who can carry the water the longest. And that's what I fall back on when I get down to that point where I don't want to go any further, because I keep remembering that the other side, and it started out with one little nobody builder with one little crooked lawyer fighting against us, and it has now mushroomed into, we actually have at this point, because we've turned around and sued all of the law firms, the various parties that were involved, a bank, there are a whole bunch of people. We have 70 lawyers that we're fighting on the other side right now, and we're winning. Okay. We will be right back.
We're changing videos, is that right, John? Oh, we're still on? Oh, we're the Irwin Rommel School of Law, and we're in Chicago at 4842 North Magnolia. And our zip code is 60640-4710. And we're telephonically connected to you 773-878-0681. Our dedicated fax is 0682 and we're going to flip a tape and probably flip out, and we'll be right back. Can I see...
Okay, we're back. One piece of information I wanted to share with you, because it's something everyone runs into their first time around in court. And if you get Erwin Rommel, the second edition, Chapter 8 tells a whole lot about our story and what we've been through and how it started out when we first got into the courts. My very first experience with my husband in the court was actually not in South Florida, but it's where I got one of my best pieces of information. It was in a small claims court up in New Jersey, where we come from. And we had gone into the courthouse. We were fighting. The people we bought our house from had sold us a garage that was infested with termites. Thank goodness it was a separate garage, but we were just trying to get our money back that we knew we would lose when we sold the house, when we turned around and sold it, because we were going to be honest when we sold it. So we had gone into small claims court, and we were fighting, and we got a settlement from the one termite inspection company, but there was this lawyer who was hanging in there for the owners who had sold us the house. And he was a real sleazy lawyer, you know, would come in. I think he owned one jacket that he slept in and woke up in and had Christmas dinner in, and I mean everything, and never went to the cleaners in between. You can usually tell the real low-life lawyers by the way they dress. And that's another thing. If you're going into court, you really need to go in looking like a lawyer. You need to go in a suit. You need to go in and know that that position, as much as we may say, whatever we say about the judges, and it may be true, and a lot of times it is true, you have to respect that position the way you were raised to respect it, because you're not going to get anywhere if you go in there with an attitude. It's not that the judge is going to like you, but he's not going to hate you quite as much. Okay? And you're not going to make friends with him. But you're going to go in there, and it gives you standing, and it also gives you confidence that you need, because you go in there and it seems to you like everyone knows everything except for you. And you walk in that courthouse door and you walk over to the first clerk and you want to file your first paper and you say, "Excuse me, I'm a pro se litigant. Can you tell me?" And they say, "I'm sorry, I'm not allowed to give you legal advice." And then you go over to somebody else and you say, I just want to know, is this the right place to put this paper in? I want to file it." And they say, "I'm sorry, I'm not allowed to give you legal advice." I mean, you ask somebody where the bathroom is and they tell you they can't give you legal advice. But that's because you're not asking the right question. When Michael and I went to that courthouse in Jersey City, we had gotten there at 8 o'clock in the morning. We went to the first clerk and we asked her, where did we go? And we had a piece of paper in our hand to file this paper. And she said, "Oh, we don't do that here." "Well, where do they do that?" "Well, you have to go here." And we got directions around these two old courthouses in Jersey City. From 8 o'clock in the morning until 4 o'clock in the afternoon, we were going from room to room to room to room, following everybody's directions. And at 4 o'clock in the afternoon, we came back to that first lady. That was the last direction we got. And we said, the woman down in the records department said, "We have to come here and talk to you, and this is where it gets filed." And she said, "Oh, that's right." And I said, "Well, this morning you said you couldn't give me legal advice and I was in the wrong place." And she said, "Well, you didn't ask the right question." And that's the key. If you don't say it the right way and you don't ask the question the right way, you're not going to get the answer. So what's the right question when you go into the clerk's office? "Excuse me, I have a procedural question that I would like to ask you," because they're allowed to answer procedural questions. That rules of court book, most of your answers are going to be in there. Okay, most of the civil book that Michael held up for federal, and you can get it for each of your states, and you have to have it. The very first hearing Michael and I went into was with Judge Wessel down in West Palm Beach, and it was after we had spent over $200,000 for attorneys representing us so that we wouldn't lose our house, and we were losing anyway. And we went into the courtroom with an attorney who had charged us $1,200 to take a look at our case and tell us what we should do. and whether or not he was going to be able to help us. And he went into this one hearing that he was going to represent us for, and there were two attorneys on the other side sitting at the table, and this attorney came in, and as he got up to the podium to talk to the judge, he said, "Good morning, Your Honor." One of the attorneys for the builder sitting at the table got up and said, "Excuse me, Your Honor, but yeah, I was talking to this attorney out in the hallway, and he said to me that he's only going to be here this morning, and he's not going to be on the record for the Daddicks, and you're not allowed to do that." And the judge went crazy, and he picked up the book, and he shook it in this lawyer's face, and he said, "You show me where that is in this book. If it's not in this book, then it's not the law. And I don't think you can show it to me." And I didn't know anything about the law, but boy, I pulled out my pen and I said, "What's the name of that book? I want that book." I got to tell you, that's the rules of court. That's what that judge was shaking in his face. And when we went down, and it took us months to find out where to buy it, because you can't get it in a regular bookstore. You have to go to either a law school bookstore or order it directly from Westlaw, and they have an 800 number. But you need that book. I mean, you cannot go in unarmed. That is your weapon in court. Procedure, procedure, procedure. We were losing in the beginning when we first started working with Michael, and we were losing because it was so messed up before we ever met Michael. These lawyers were just filing papers. We have, seriously, been to more than 500 different hearings in our cases. Not hearings that we set, hearings that the lawyers set. And why? Because they want to run us out of money. And if we had to pay a lawyer, they would have run us out of money a long time ago, and we would have lost our house. But if we can do it, all of you can do it, because there's no trick. It's just paying the price. It's wanting to know. It's wanting to learn. And if you want to be able to use your court system in this country, you've got to learn this today. Because I'll tell you something, I don't care how high the stakes. Nothing would make me hire a lawyer again. We kept thinking, there was always this pulling in the back of our minds, maybe we're going to find this magical lawyer who's really going to pull us out of all this trouble. So we started out with an $8,000 mechanics lien that we were fighting because we knew we were right. And when we went over $200,000 in legal fees, we said, how can this be happening? But it can, and the judges let it go on. But it wouldn't happen if you're in there fighting for yourself. So I think the major thing that you have to keep in mind is that as long as you're willing to keep going, and you're willing to find out what the laws really say, and go by the things that you've learned here. You've learned such valuable information here yesterday and today. I can't tell you, if I would have had that, we would have won a whole long time ago. But I wanted to mention a couple of other things, just kind of disjointed topics that I think are real important. The things that you learn here can be applied in your local government, so that if you want to make changes on a local level. Did you have a question? Yes.
Peggy, how can you stand up for yourself in court? What can you say to a judge to let you stand there and defend yourself?
Well, you don't have to, okay, you always have the right to represent yourself unless you have a lawyer. Okay, if you have a lawyer, the minute you walk into that courtroom with a lawyer, you have given up your right to speak. And a judge will tell you that. He'll say to you, sit down, you have a lawyer, he can talk for you. But if you go in on your own, all you need to do is file your paperwork. What type of situation are you talking about?
Oh, I'm talking about we feel we'll probably be in many situations, because we're drawing that to us. That's why we're here.
Okay. Okay.
But I want to know how you can do that, how you can just be your own defendant without a lawyer, because I thought you had to always have a lawyer or they will appoint you one.
You can, okay, there are two different types of situations. You can be in a criminal court where you're a defendant and they've accused you of doing something wrong criminally, okay? Or you can be in the civil courts where you're fighting for your landlord about the rents, or you're fighting your local county commissioners because you don't think they should take your tax money and build the roads that they're building, or a whole myriad of different things. And that's just done by initiating, if you want to, let's take an example with the county commissioners. You're not happy with what they're doing with your tax dollars on a specific item, let's say a road that they're building. And you fight it out, you go to the hearings and you voice your opinions and you fight there. but they pass it anyway, and you know that they don't have a right to do that because their local rules say that they're not supposed to be doing that. Then you can file a lawsuit against them and sue them civilly in court for denial of due process or for ignoring their own rules. And that depends on what your case law says in your state. For example, in Florida, we have case law that says if a state agency ignores its own rules, that's a denial of your due process rights under the 14th Amendment of the Constitution. Bingo, you can go into federal court with that on a Title 42. And that's the way people can make real differences in their local governments. Because today, a lot of the problems that we run into, I tend to think South Florida is the worst, but I guess it's just because I live there. But we go down and talk to our county commissioners, and they fall asleep, or they're having side discussions, and you're allowed to get up there and talk, but nobody pays attention to you. And that's just getting worse and worse. And the answer is in the court system. That's what the system is there for. But it's not going to happen with attorneys, because they're not going to fight the local politicians. Because if they do, it's political suicide. And so you're not going to get somebody to go fight that issue for you unless you're lucky to run into that one renegade lawyer who wants to live on a mountain by himself. Okay.
Thanks.
All right, you're welcome. Let me just see. I think I have a lot I'd like to say to you, but that'll have to be another seminar. I could probably go on for days. Did you have a question? You'll have to get up to the mic.
Yes, Peggy, about the fighting at a local level. About a half a year ago, I filed a lawsuit at the state level, and they had raised the filing fee from $60 to $187. And I said, why? And they said, for the law library. So when I wanted to use a Lexus in the law library, well, I can use the law library. When I wanted to use a Lexus or go at night like everybody else, attorney does, they wouldn't let me. So who?
Well, you can certainly fight that out in the courts. So you can
but at the municipal level, who is responsible for that? I can't find anybody to take accountability.
Okay, well, you have to go and ask questions down at the courthouse and find out who is it that funds the law library, and start from that point to find out who does the controlling financially. That's really where your answers are.
Who controls financially, like
right.
City manager or something like that?
It would be ultimately some political group. It might be your county commissioners if it's a state courthouse.
And what would be the name of the suit? I'm sorry to be so elementary, but what would the suit be called?
Well, it might be a denial of equal protection under the laws. I mean, it might be that type of situation. It depends on all the details, because if there are people that are being allowed and some that are not, and you're
attorneys versus people who paid the same.
Right, but you need to really do the research on that and to find some case law to back up your position. It doesn't have to be a library. It just has to be a government situation where the money's going into one, and you have two groups of people that are being treated differently.
Okay, thank you very much.
Okay. Thank you very much, and we're going to turn this over to Ed.
In terms of being denied access to a law library, basically you're going to be suing the landlord. And remember, you're a taxpayer, and the taxpayer funds and supports the library, and so he's denying you the use of your own property. And so that would be the issue you would probably be desirous of litigating. Direct from the great state of Pennsylvania, the Keystone State, one of the Keystones, Ed Guadelli.
Morning. A long time ago, William Shakespeare said, first thing we do, let's kill all the lawyers. By the time I'm done with my story, you'll be able to see why. Little correction I'd like to make. The reason there's a cement truck on the back of the Bora here, for about 25 years, my dad had a successful concrete business. They did work for local county, municipalities, things like that. At the end of round one with the federal government, we had a couple trucks left. So what we did, we improvised, adapted, and overcame, and we started a trucking business. So that's a little memento of what we still have. Along those lines, my dad's business with the county started about 1980. And he happened to be friends with the maintenance director since high school. And it was a 3-year investigation by the government, and basically what they wanted to do in our county, Allegheny County, where Pittsburgh's located, is they wanted to shift the balance of power from the Democrats to the Republicans. Democrats were in power for about 60 years. And for some reason, the government wanted to get involved, and they came out with a smear campaign alleging all kinds of wrongdoing, kickbacks, things like that, and they got the media to do their work for them. You know, the media did all their dirty work, and when you see something in the papers and on the radio, TV, long enough, you know, you can convince people that the moon was made of green cheese. Located is they wanted to shift the balance of power from the Democrats to the Republicans. Democrats were in power for about 60 years, and for some reason the government wanted to get involved, and they came out with a smear campaign alleging all kinds of wrongdoing, kickbacks, things like that, and they got the media to do their work for them. You know, the media did all their dirty work, and when you see something in the papers and on the radio, TV, long enough, you know, you can convince people that the moon was made of green cheese. So right before the primary elections in 1995, the indictments come out, and needless to say, the county commissioner that my dad was friends with, he lost the election. Okay, so it was a politically motivated incident, and a little bit about that was about 1993, the FBI and the IRS started coming out to my dad's business. And they said basically, oh, we're looking at public corruption here, we're looking for some sort of wrongdoing. You're not a target. They told him over and over, you're not a target. Give us a little information. So my dad called his attorney, a man by the name of George Blissman. He had done Dad's legal work for years, wills, deeds, contracts, things like that. And the first thing he told him was, oh, it's the government, cooperate with them. Tell them whatever they want to know, give them all the information they need. So my dad did. He wasn't all that knowledgeable about the law. He figures you'll hire an attorney, and the attorney will know what to do. Every time the FBI and the IRS come out to my dad's place, you know, they always did their business with them out there. One day they showed up at our house. They had a subpoena to appear in front of the grand jury. So they gave my dad the subpoena. He appeared in front of the grand jury. He took George Blissman down with him. In grand jury proceedings, you're not permitted to take an attorney inside with you. He can stay outside, and if you have any questions, you can go and ask him. At least that's how it's supposed to work. So the U.S. attorney, Jim Garrett, kind of looks like the Crypt Keeper from HBO. He was asking Dad questions about things that happened 9 years ago. And my dad didn't have any notes or anything to refresh his memory. And he told him the best he could, as Blissman told him to. He cooperated. And because he didn't tell the U.S. attorney what he wanted to hear, he threw out a charge of perjury. So when the indictments come out a year later, one of the charges against my dad was perjury, simply because he didn't tell the U.S. attorney what he wanted to know or what he wanted to hear. When you're going up against the U.S. government in court, you're going up against the limited resources. And they will do anything they can to win against you. They will lie, they will cheat, they will steal. But you have to follow the rules. So, the best you can do if you're going against them, you've heard of people doing it before, you act as your own attorney. Because if you're going to hire some land shark, he's going to take your money, and no matter what happens to you, he's getting paid. And a lot of the times he's not going to raise issues that you want raised. For example, during the trial, we told this attorney that we have, during the search, they sprung a search warrant on Dad's business. Even though he was cooperating with them, they still felt the need to come out with a search warrant and 20 agents and take all his records. They took, the search warrant said that they could take up to 1993's records, but they took 1994's records also. And one of the IRS CID agents, those are the guys that carry guns, when he was told that he could only take the 93 records, he says, "We're the government. We'll do whatever we want." And he took 94's records anyway. When we tried to make an issue of this, our attorney wouldn't raise it. Seems to be that he was afraid of getting the judge mad at him. He says, "I'm going to have to go in front of this judge with other clients." He says, "I don't want to make him mad at me." So because of that, issues weren't raised. And at the trial, it went in front of a corrupt Reagan appointee, the Honorable D. Brooks Smith, in the Western District of Pennsylvania. And he basically acted like a second prosecutor. Okay, he wasn't interested in the Constitution or anything like that. He was interested in seeing that the government won. It was basically what it was about. So, needless to say, the jury being exposed to the media coverage, for 2 straight years, they were convicted in the media first, and then the jury convicted them. So right now, my dad's down in Morgantown, FCI. But because of what happened, I got interested in the Patriot movement. And one day I was flipping through a copy of the Spotlight magazine, and I seen an ad for Erwin Rommel School of Law. And I thought, I'm gonna give these guys a call. And since that time, Mike and I were able to file an assault against the grand jury proceedings. And then the day my dad had to report down there, because the government will let you do 2 things. They'll either let you self-report if you're going to be incarcerated, or the U.S. Marshals will take you away kicking and screaming in handcuffs. On the day Dad self-reported, I went back to the federal courthouse and filed the grand jury assault. And the government wasn't expecting it. They figured when they've won, you're just going to roll over and die and give up. And what you're learning here is basically how to do some unorthodox stuff in the courtrooms that the government or whoever, they're not going to be ready for. And your greater chances of winning go that way too. Anyone here see the movie The Last of the Mohicans with Daniel Day-Lewis? During the French and Indian War, which a lot of it took part up in Pennsylvania, where I'm from, one day a British expedition set out from Virginia. It was headed by General Edward Braddock and a young colonel with the Virginia militia, George Washington. They were on their way to Pittsburgh to attack Fort Duquesne, which was held by the French. On their way to the fort, they were marching traditional rank and file with the bagpipes and the drums, and the French and Indians ambushed them. They took heavy losses, and George Washington told Braddock, he said, advise your men to take cover behind some trees or rocks, because that's where the Indians and the French were. And the British, they were used to fighting on European battlefields. So they lined up, traditional rank and file, and they were decimated. Edward Braddock was mortally wounded, and they were eventually routed, and they retreated back to Virginia. Well, that's what Erwin Rommel was basically teaching you how to do, is be like the French and Indians. When you're doing some of this unorthodox stuff, they're not going to know how to handle it. So I want to wish everybody luck in your pursuits, and if you have any questions for me, I'd be more than happy to answer them, afterwards during the break. Thanks a lot.
Good morning. My name is James Jackson out of Brooklyn, New York. I have a very interesting case in New York's Supreme Court. Okay, my case is that there was a shooting in my driveway, 4 o'clock in the morning. Not what I say, but what medical records state, that the victim who was shot was under a psychoactive drug. You have no gun, no shell casings, let alone shell casings with my prints on it. You have no neutron activation analysis, that's just powder residue on your hands. None of this. But yet, I was arrested. I face attempted murder, assault in the first, assault in the second, criminal possession of the weapon in the third, criminal use of the weapon in the fourth, for reckless endangerment, a 7-count indictment that's supposed to terrorize me into submission. And they will not get that submission. I'm fooling them. They picked on the right one. In New York City, we have to have license for our firearms. My mother-in-law owns the house. She's on the first floor. We're on the second floor. There is a license, 357 Magnum, in the house. I have rifles and shotguns. The person who was shot was not shot with neither one. They have nothing but the testimony of someone on a psychoactive drug stating that you shot them. Where they weren't supposed to be 4 o'clock in the morning, you went to the grand jury, you stated that it was you and another person. The other person got on the witness stand, stated that it was you, them, and a third person. Police reports have such names like Arkee's cousin, or a friend of mine, Sam. You have 4 grown men who are unaccountable for 4 o'clock in the morning, but I'm the only male in the house, is arrested for attempted murder. In jail 4 weeks, 6 weeks, 4 weeks remanded, no bail. When the bail was set, I was terminated from my job. I had 20 sick days, 20 vacation days, and 6 sick days. All of that went down the drain, and they think I'm going to give up this fight? I don't think so. I put in a motion. I didn't testify before the grand jury. We put in a motion. Judge denied it. Put in a motion to inspect the grand jury minutes. We've inspected the grand jury minutes. We find nothing wrong. Well, what about the prosecution's witness never get charged with perjury? Okay. Put in a motion to dismiss the indictment. Deny. Why? You have a 7-count indictment. You used 5 counts. You just reworded the word and worked it all around 1. So that means you double jeopardy in the indictment and the other 2, but judge, out of his own vain heart, decided motion denied. They don't know where I'm getting my information from. Where are you getting your information from? Who have you been talking to? Well, pardon me, I know how to read. I come into court, Black's Law, 6th edition, CPL law. They're wondering, where is he getting his information? We filed an Article 42, Title 42 on the judge in federal court, Article 28, 2201, 2202, and they're amazed. I'm supposed to be laying down and dying right now, and it's not going to happen. I've spent 6 years United States Marine Corps. They taught me how to fight, and I'm not laying down for this one. At that note, they don't know how to take this. And I'm quiet in court. The very times that I am quiet, I'm filing papers in federal court. Judges looking at me and they don't know how to take it. Where is he getting his information? They've done a microscope on me. I mean, put me under the microscope and dissected and everything. Know all my finances, who owns the home. They're stating that if I could come out on a substantial bail, I could afford to have paid legal counsel. I stated to you, Your Honor, it is not financially feasible at this particular time to have paid legal counsel. Every penny I had and did not have is went into bail. Well, where did the money come from? I have affidavits from Kansas, Florida, my mother, my sister, family and friends. Folks know my character. That's why they entrusted and put finances so that I was able to get out. Well, you're going to have to do it anyway. Well, show me the law. The Sixth Amendment of the Constitution say I have the right to counsel. That doesn't say because I'm supposed to rub my last 2 nickels together and come up with ineffective legal counsel because you want me to. Right now, when I've spoke to a legal aid on the Constitution, well, the judge violated my Constitution. Don't quote the Constitution to me. Well, okay. I hung up the phone. Now they're found in federal court. Oh, now, have you talked to anyone? No, I haven't talked to anyone. Now, judge comes in. He's an hour late to get on the bench. He's never late. They don't know where to take this. They're trying to tie my life up, and I'm not trying to go. And the bottom line is, we come to battle. We have court transcripts that state, this is the battlefield. The law is the weapon. Well, now are you getting offended because I'm standing up for myself? What am I supposed to do? Put my head down, look at your shoes, and take 10 years in state prison? I don't think so. Not for being home 4 o'clock in the morning. And that's the gist of my case. And right now, we're going to take a short break. No, question, correction.
Legendary or true, it is said that George Patton, addressing his staff in a temporary headquarters billeted in North Africa, as he explained the next maneuver that they were going to run against the Africa Corps, he walked to the door and he turned around and he said, "We will go forward and meet the enemy and be victorious, or let no man come back alive." And it's refreshing to see people like James Jackson who understand that maxim in 1997 in urban America. Erwin Rommel School of Law is honored to have the national chairman, is that right, of the Fully Informed Jury Association, Harvey Weissong.
Well, thank you, Peter. I'm the spokesman, but that's close enough. National spokesman for the Fully Informed Jury Association. Ladies and gentlemen, there are some matters of criminal law that we've dealt with over the years in the jury movement, and incidentally, the fellow who first involved me in this whole thing is with me today. Reg is first handed me a little brochure several years back that said, true or false, the jury has the right to decide matters of law as well as fact. He handed it to me at a little political gathering that we had every week. It was just a little group of friends that got together to discuss political matters every week. And he said, and of course we're all a bunch of zealots, so we all brought copies of articles and books and things that we wanted everyone else to read. And we all walked in with our stack of paper and walked out with a stack of everyone else's paper. And among the papers was this little yellow brochure, the true or false brochure that Reg handed me. And as he handed it to me after dinner, he said, "Harvey, read this. It protects everything we believe in." And I thought to myself as he handed it to me, what you mean, we? because Reg and I differed on a couple of issues that were significant. And I read it a couple of weeks later when I got down to it, and he was right. The jury issue protected us all. Now, one of the things that has been neglected has been the grand jury. The feature has concentrated on the trial jury, but we will be focusing on the grand jury. At least Harvey Weissong will be. And Harvey Weissong is going to be working very diligently with Mike on this 372 campaign, starting with our friend Rudy or anyone else that we can find that'll step in front of the crosshairs. A friend of mine told me, a very great political strategist up in Virginia told me, you don't go actively seeking revenge in politics. You figure your range, you set your rifle up, you get your crosshairs there, and you wait, and you leave it. You might have to leave it for a year or a decade. Sooner or later, he'll step in front of the crosshairs. You pull the trigger. That's all there is to it. But you don't go looking for your revenge, you just wait. These guys all slip up. And if you're waiting, if you're ready, you'll do it. Now, let me tell you one thing that Mike and I have discussed, and I think it might be appropriate to put it on the record here, and that is a closing argument that I've been trying to get some friends to use in criminal trials. This I call the snitch close. And the snitch close, Mike, does that seem like an appropriate thing to go on here? Would you rather go with the theory of the jury? Okay. All right, let me just, let me put this out and just hope and pray that somebody will start using it. Very often, people are brought into court, and the only evidence that the government has against them is the word of a convicted felon or someone who is under a felony indictment or under threat of felony indictment. And the time that they're looking dead in the eye is about 20 years, maybe 40, maybe, you know, whatever. And they've been offered a deal. And I saw it happen in the case of a couple of friends, people whom I befriended after they were in trouble in a so-called drug case. And the sentence reduction offered to a fellow was to go from 20 years, slam dunk, he was going to prison for 20 years, or he was going to go to prison for 18 months. All he had to do was stand up and perjure himself against these poor, hapless defendants that the government had decided were the ringleaders of a multi-state drug conspiracy because they were selling light bulbs and fertilizer. Didn't have any idea whom they had sold it to. So, guess what the witness decided to do? He decided he was going to take the 18-month deal, and they were on their own, the other folks. They could testify against someone else. They could perjure themselves against someone else to get their sentences reduced. So what I decided was, as a closing argument, you'd come to the jury and just say, ladies and gentlemen of the jury, now you're going to have to polish this up. This is a little bit rough, but you'll get the idea. Ladies and gentlemen of the jury, I've been working on some legislation, and we're proposing this legislation for the United States and for the state of whatever state you're in. And it has to do with the testimony of witnesses who are operating under some threat, some coercion by the government. And we would call it perhaps the truth and testimony law. And what we would do is before the trial, we would require that the court, through its minions, would determine what the fair market value of the snitch's services are on the outside. What is the fellow qualified to do, and how much money can he earn doing that on the outside? That would be his fair market value per year. And then we would, after he testified, we would recess the court, recess the trial, until the court had held a hearing to determine how much his sentence reduction would be. You see, it can't be agreed to before he testifies explicitly, but we'll just interrupt the trial and say, all right, now that you've testified, we'll hold this hearing, we'll determine how much of a sentence reduction you get. And after that's done, we now know how much he can earn per year in a fair market situation and how many years he got reduced off his sentence. We then bring the jury back in, tell them what his fair market value is. We would also tell them how many years reduction in sentence he has received. We would multiply the two figures together. Let's say the guy can only earn $12,000 a year. Let's say he gets 8 years reduction. What is that, about $96,000? Something like that? I wasn't a math major, but we'll see. So when he's finished testifying, when the jury's back in here, and while the jury watches, the witness then must walk across the courtroom to the prosecutor's table. And the prosecutor pulls out a stack of $100 bills. And while the jury watches, the prosecutor counts out $96,000 and hands it to the witness in payment for his testimony. Now will the jury believe that man? Will the jury believe his testimony when they see him paid $96,000 or $150,000 or $200,000? And how much would you pay for your freedom if you were sitting in jail for under a 20-year sentence and you were offered the opportunity to get out on the outside? You had a big bank account. How much would you pay for your freedom? How much you'd pay every single penny you had in the bank? If it were 50, if it were 100, if it were $1 million, whatever it is, you'd pay. That's what Mr. Snitch's testimony has been worth to him in this courtroom. Every penny he may have in the bank, every piece of property he may own, and the $96,000 you just saw the prosecutor pay him for his testimony. Now, do you understand why he testified the way he testified? He perjured himself for $96,000 and his freedom, which is priceless. That's what I'd say. That is my suggested closing argument, and I hope somebody will have the opportunity to use it and secure his or someone else's freedom. It was going to be used in a recent trial, but the defense attorney was removed from the case by the judge, so it didn't get put into play. Now, how much time are we working with, Peter? 3 minutes. 3 minutes. There is another close that has been used, one of mine. It has been used in a marijuana trial, and it worked very well. This was in California in front of one of the hanging judges known as Maximum John, I think it was, or Maximum Jim, whoever. Gives you an idea of what you're up against. And you can't give fully informed jury instructions. You can't tell the jury, if you're a licensed land shark, tell the jury that their authority is to ignore the law when they find it is either ill-advised or for whatever reason they don't want to implement the law. They find it unconstitutional, they find it inadvisable, and if the jury feels that the law is being misapplied, and that is called jury nullification. But what we did in California was to use a close that went something like this. Ladies and gentlemen of the jury, you've heard an awful lot of facts. I mean, we've been at it now for several days. And I guess you just about fact it out. And you've heard a little bit about the law just every so often here. And yet, you're going to hear a good bit more at the close, after these closing arguments. You're going to hear a good bit more about the law from the judge. This court will instruct you all about the law. So when you leave here, you're going to know an awful lot about two things: facts and law. And what we're told is that you're going to be able to arrive at a verdict with just those two elements. And in fact, is it only facts and law that should go into your verdict? I mean, isn't something missing? Have you noticed that during this trial, we've never spoken one particular word? We've sidestepped it, we've evaded it. Ladies and gentlemen, it's the J word. And no one in here will mention that word. No one will give you instructions in it. It's even in this man, the prosecutor's title, but he won't say it. The word is justice. Whose business is justice? This court won't give you instructions in it. Ladies and gentlemen, if you didn't bring it into this courtroom in your heart, you're not going to be able to put it into the verdict. And that's the issue here. So we got justice in, and that resulted in acquittal. The judge said, as the jury came back in the courtroom, you just never know what a jury's going to do when people start throwing around words like justice and conscience. Those are the two words. Thank you very much.
Thank you, Harvey. We are the Erwin Rommel School of Law, and our info pack is free, and you get it at by contacting Peter Simpson, care of 4842 North Magnolia in Chicago, 60640-4710. 773-878-0681 is the voice. 0682 is the fax. Stay close to your chairs. We're going to turn the tapes around, and we'll be right back. Thank you. Close to your chairs. We're going to turn the tapes around, and we'll be right back. Thank you. Welcome back. The Erwin Rommel Mobile Law School Live Seminar in March of 1997 at Charlotte, North Carolina was graced with 3 sponsors, and they are the Canaan Project, works as opposed to what ought to be. This is the director of Road to Freedom from Arizona, William Sanford Gadd. Mr. Bill?
Thank you, people. Peter asked me to come up here just to give you a little background on what I know about Mike and the program of Erwin Rommel. Approximately 3 years ago, somebody had picked up to do the seminar there and dropped the ball, and I had been talking to Peter and he asked me to pick it up. So we were able to still put a small group together and salvage it. Mike had worked with several different people in Arizona that I am personally aware of, and I'm going to tell you a little story about one and how well what happened worked, and how at this point what she is doing is completely faltering because she has stopped following the program. The story is there was a gal that there was a tow truck driver who was literally stealing a car out of her driveway. She went outside with a gun in her hand to stop him because she heard her daughter scream. The ensuing thing with the Scottsdale Police Department ended up getting this gal charged with a felony of assault. And this guy is a big, burly, knuckle-dragging guy that could have very easily hurt either one of them. I had known the gal probably for about 4 or 5 months and was very helpful in telling her, do not roll over, do not play dead, and fight. T-shirt I wear is never give up, and most of you who know me have seen this thing on everything that I ever do, because I want to remind you, the only ones that lose are the ones that give up. Well, she worked with Michael probably for approximately 6 or 7 months. A lot of things going back and forth, FedEx, mail, everything else. And what happened in the long run is they dropped the charges, which is literally almost unheard of in Arizona. They never drop charges in Arizona. Okay? Since then, she has embarked on a very interesting Title 42 campaign against government officials, working with 4 or 5 different groups that have come in and out of Arizona, which I will not name for obvious reasons, so we don't step on anybody's toes. And everything that she has done is literally fell to the wayside, along with a lot of other people she has worked with, because she has not followed the Erwin Rommel program. Now, that doesn't necessarily mean you can't take other things and intertwine them, because of course this is an informational thing and you have to look in the law library and find out what works and what doesn't. Because, as Michael will tell you, the law is not what I tell you it is what the book says. And that's very important. Another thing that is going on right now that I have been helping somebody with personally is a criminal case that's going on in Arizona right now. I have been using the tactics of Erwin Rommel to literally push them to the wall. What has happened at this point, we have one judge that recused himself. We had another judge that kept the courtroom locked and wouldn't let the guy in and sent the bailiff out to tell him that she recused herself before he even got in there. The third judge went in and let him just say his whole piece and said, do you need 60 or 90 days? Continuance. So it just goes to show you, if you keep nailing them, they will, of course, eventually falter. The more things you give them, the more mistakes they are going to make. All right? That's basically all I have to say, and I will tell you that the Erwin Rommel School of Law books are probably some of the best written. Mike Brown's lawsuit cookbook, I personally did one thing with that. I used it to write a lawsuit against an apartment owner without filing it, dropped it on him, and the next thing I knew, I had a check in the mail for the deposits. So sometimes you can use tricks without filing things, and scare them enough. Well, that's about all I've got to say, and here is Peter John Simpson.
Thank you, Mr. Bill. This is case analysis time. When you hear your particular dilemma being discussed, please take your warm body to one of our 2 audience microphones, and there may be a modest question and answer period ensuing. There may not be. We never know what Michael's going to do, and that's one of the sheer joys of working with him. Each seminar is a surprise, and each day is a surprise. This is case analysis time, Michael.
What I want to do is, before I get to case analysis, and I'm not going to ask everybody to come up front and center because 7 of you are up for court-martial, and I'll explain that in a minute. So I don't want you coming up here and embarrassing yourselves. But one of the things I want to point out, the last stunt that Bill Gadd just described, if you mail a threatening letter to somebody and threatening with something other than legal action, that's considered extortion, blackmail. But if you send them a copy of a lawsuit you're about to file, that's extortion and blackmail. That's legal. They can't do anything to you about it, and you'll find it under compromise and settlement, both in am juris secundum and corpus juris secundum. A couple other things I want to, because like Peter said, you know, I'm a little unpredictable because I like to play off what other people are doing. It's a lot easier that way. Don't have to think as much. One gentleman a while back, he said that, well, you know, some of this other stuff you get, you know, you can sort through it, and, you know, there's some good stuff and bad stuff. Sure you can. And how many people here, I want to see a show of hands, that if you're going to get from point A to point B, and you have to go across about 100 yards of open field, and there are mines in it. Now, your objective is on the other side of this minefield. How many people would leap right in if you had a map to that minefield that was 90% accurate? Okay? That's what you're doing with a lot of this crap that's floating around. Now, when Harvey pointed out that a defense attorney was removed, let me point something out in a criminal case. They did the same thing to John Gotti. He had a guy named Bruce Cutler who was a real, I mean, this guy was a racehorse. He beat every case John Gotti ever had. So the government pulled the same fast shuffle and got rid of him. Guess who they can't remove? If you're the defendant and you're going pro se, ain't a damn thing they can do with you. All right. Now, next thing I want to get to, well, a couple of things. What Harvey was describing about piling up all the money in front of the snitch, that's never going to pass for one very simple reason. What he was describing, though, because the grand juries don't work properly, is found at Title 18, United States Code, Section 201, bribing a witness. It's a felony, and the people who assist the person in bribing the witness, you'll find that at Title 18, Section 2, 3, and 4, which is aiding and abetting, accessory after the fact, and misprision of a felony, and of course subornation of perjury. You'll find at Title 18, I believe it's around 1623. Isn't that what a plea bargain is, though? Well, of course it is. Throw that man a fish. Anyway. Yeah. Hang on. Microphone, Harvey, please.
You do notice that I set it up as fiction to be described to the jury, since you can't actually do it. You say, this, you know, it's almost an I have a dream speech.
But the thing is, you better be careful to do that in your opening remarks, because that, see, what'll happen is when you mount a preemptive strike, it eviscerates the defense. One thing that they are not ready for in these courtrooms is somebody coming in and hitting them with something that's legal, all right? Now, I've got a lot of people here that I can see have been misled in you know, quite frankly, more than I suspected. But one more thing I want to cover here before I get into the case analysis is I've had a lot of volunteers. I appreciate that. This is definitely what you would call an elite unit of shock troops that are going to help me out with crossing the T on Federal Judge Rudy M. Brewster on a 372C1. And you have 2 ways to go with this. And before I give you the 2 ways, let me point out one thing, one reason that this is so important at this particular time. As Sun Tzu will tell you, that there is a time to strike. If you've ever watched a hawk strike a sparrow in midair, the timing is everything. The British, for example, lost the Battle of the Somme. 150,000 men came out of the trenches. Everything was timed perfectly. There's just one minor little glitch. What they were planning on is they had a rolling artillery barrage. They were planning on keeping all the Germans down until the British infantry could get right on top of them, and then it would be a cakewalk. Well, in the planning stage, that was absolutely correct. But their timing for their artillery was off by 8 minutes. And in those 8 minutes, the Germans all came up out of their trenches, and 150,000 British soldiers went out. 67,000 of them did not come back. Happened in one day. So that's why the timing is critical, and the reason the timing is critical on this, it's time to cross the T, and if those of you who feel like writing congressman, I would also appreciate that, is that this particular statute is up for reconsideration this year, not to repeal, but Congress, after 16 years, has realized it doesn't work, because the way this works is it goes to the chief federal judge of the circuit. Title 28, United States Code, Section 372, Paragraph C1, complaint for judicial misconduct. And some congressmen apparently figured out the solution. Instead of sending it to the chief federal judge of the Ninth Circuit, which is the most corrupt circuit that has ever existed in the history of the United States, if this particular bill passes, and those of you who write to me, I will furnish that information also with the numbers. Those of you who have Son of Erwin Rommel, it's already in your book. But if this bill passes, this complaint that goes to the chief judge of the circuit in which this judge is employed will now go to the chief judge of another circuit. So he's got no motive to protect the corrupt judges in the Ninth Circuit. You can write to the clerk, United States Court of Appeals, and those of you who want to can come up here during the next break and write this down. If you want all the forms and instructions from them, it's Post Office Box 193939. Again, that's Clerk, U.S. Court of Appeals, Post Office Box 193939, San Francisco, California, 94119-3939. Or you can write to me, Mike Brown, Post Office Box 4884, Springfield, Missouri, 65808. And I will send you all the forms and instructions. And Harvey brought something to my attention during the last break, and he pointed out that I probably should bring up the fact there isn't any way they can retaliate against you for this. And the other thing is that you don't have to have standing to file one of these complaints. See, normally to file any type of legal process, you have to have standing. There's nothing in the statute that says you have to have standing, and I'll absolutely double damn guarantee you that no matter what the judges do with it, these complaints will wind up in the statistics of the Administrative Office of the United States Courts that are reviewed at least once a year, and if 2,000 complaints wind up against this one federal judge, I guarantee you people in Congress are going to look at it. Let me tell you how I know. We had a girl out in Las Vegas. Now, she despises the Ninth Circuit just about as much as I do. She's been battling them for several years. And I had explained to her how we were going to cross the T on this particular federal judge. And because she was involved in some kind of child custody squabble, apparently there's a lot of corruption in the Nevada courts that's more extreme than the corruption in some of the other courts in some of the other states, so that there's been a federal investigation. Well, one of the congressional staffers, and let me point out, which is also in your book, that the people who really run Congress are not the congressmen. They're too busy. It's the staffers. The staffers are the ones who get things done. And a staffer for one of the members of the House of Representatives called her, and they got to talking, and she was talking about this child custody business, and somehow or another they got on the subject of the corruption of the federal judiciary, and she said, well, you know, we're going to take out some of these judges in the Ninth Circuit. And he said, well, how are you going to do that? She said, you know, your complaint for judicial misconduct? She said, we're going to get hundreds of people to cross the T on one judge. And she explained it to him. She said, the guy started laughing. He said, that will work. So we have it right from Washington, D.C., that it will work. Okay? Now, I'm going to get into I've covered all that. What I'm going to do first, now, let me warn you, people, and I'm going to warn you and warn you and warn you and warn you again. I don't care if you're right. I only care what works. All right? You know, this is not a moral issue in these courtrooms. I mean, if you're looking for moral issues, go to church. Do not go in an American courtroom, because what you're going to have to deal there with is slime. So it's immaterial whether it works or not. And let me give you another sort of garbaged up quote from Sun Tzu. It's been a few years since I read this one. But after reading about half a dozen of these, I can see that some of you have not learned. There are some rivers not to cross.